10 seconds, 5 seconds, start. Now, so far as claim number 2 under the head fixed cost is concerned, the learned senior advocate has heavily relied upon clause 8.2 of the CMDA. It is submitted that due to the lapse on the part of the respondent was unable to take delivery of the coal for the financial year 2013-14. It is submitted that there was an event of default by the respondent as planned in clause 8.2 of the CMDA. It is submitted that due to inability of the respondent to take coal as per the stated delivery schedule, the appellant had to operate its plant at the suboptimal level, which resulted in incurring fixed cost. It is submitted that it was mandatory for the coal to be lifted within 3 months of the production to prevent spontaneous combustion and to ensure that there is no hazard to the plant. It is submitted that despite this, the respondent failed to take delivery. It is further submitted by the learned senior advocate appearing on behalf of the appellant that the High Court has committed an error by not granting the said claim on the ground that the loss was incurred by AMPL under coal mining services agreement to which the respondent was not a party, and secondly that loss of rupees 78 crores is not substantiated beyond the chartered accountant's certificate. It is further submitted by the learned senior advocate appearing on behalf of the appellant that CMDA does not prohibit appointment of AMPL as a subcontractor, and in fact any such appointment was approved by the appellant, and therefore AMPL cannot be said to be a complete third party to the CMDA. It is submitted that therefore when the respondent failed to lift the fixed quantity of the coal and there was a delay in taking the delivery of the coal for the financial year 2013-14, the appellant shall be entitled to the loss suffered to the extent of rupees 78 crores. It is submitted, therefore the High Court has committed a grave error in disallowing the said claim. Regarding claim number 3 is concerned, it is submitted that the High Court has erroneously held to make deductions from the bills. It is submitted that as such the learned sole arbitrator rightly came to a conclusion that the stage of closing mines had not been arrived at, and therefore the deductions to make the payments into escrow account were premature. It is submitted that the issue of deduction would arise only after a passage of 30 years at the time of closure of the mining plant. It is further submitted that the deposit of amount in the escrow account had arisen due to the guidelines issued by the Ministry of Coal, which was subsequent to the execution of the CMDA.